We have all heard a saying that justice delayed is justice denied. But do we have methods that ensure justice is delivered on time? Yes, that's where ADR comes in. So, the ADR methods have been designed to settle the disputes outside the courtroom with the help of a neutral third party. As the traditional method of dispute resolution, that is the litigation, failed to ensure that the justice is delivered on time. That's why litigation becomes very lengthy process that leads to unnecessary delays in administration of justice. This is the reason why ADR methods become important for the people whose cases are pending before the court. So, while discussing ADR methods, Section 89 CPC becomes really important. This provision empowers courts to refer the dispute for alternative dispute resolution if there exists some elements of settlement or the issue is of a petty kind or would take away the precious time of the court which can be utilized for an important case. So, now let's understand what are the legal provisions that govern these ADR methods. Arbitration and conciliation are governed by Arbitration and Conciliation Act 1996. And for mediation, we have a new act, Mediation Act 2023, that was recently passed by the Parliament for this purpose. But for negotiation, we do not have a specific statute yet, but we may expect some enactments for this purpose in the coming future. And for Lok Adalats, we have Legal Services Authorities Act 1987. Now let us understand these ADR methods quickly. If we talk about arbitration, then in this case, a neutral third party, that is an arbitrator, he reviews the evidences like a judge and passes a binding decision like a court decree. But in this case, in arbitration, we do not call this order a court decree, but we call it an arbitral award. So both the parties are supposed to abide by that award as this is binding in nature. This is the reason why the order of the arbitration and the entire proceeding is also known as the private courtroom, as this involves adjudication like a court. But if we talk about conciliation, then a conciliator only facilitates both the parties in reaching an amicable settlement, but he cannot pass a binding decision. So that's why this is the reason why arbitration is different from conciliation. In arbitration, there is this binding judgment, but in conciliation, there is only a friendly settlement, and a conciliator cannot pass a binding order. A mediator is also a third neutral party that helps both the parties reach an amicable settlement. He cannot pass a binding decision or any kind of order upon the parties. He creates an environment that helps both the parties reach a mutually agreed settlement. In the end of the mediation, both the parties tell their final decision to the mediator, and that's how the mediation proceeding is conducted. Negotiation means two parties trying to resolve their disputes on their own. It is said that it is wise to exhaust negotiation before resorting to arms, means it is really important to have one on one conversation first, then to go to court. So, we must try to exhaust all these ADR mechanisms first and then approach court so that the precious time of the court can be saved. Now, these are some of the benefits of ADR mechanisms. They are time saving, they are confidential, and so on. So, we must try to exhaust these ADR methods before approaching court. So, thanks for watching.